preamble is the mirror reflection of the provisions of the Constitution. Now, these provisions were already there in the text of the Constitution, but they were not reflected in the preamble. So, through 42nd Amendment, it was there. Now, the constitutional validity of this amendment has been upheld by the Supreme Court in the Minerva Mills case. I'll take you through the chronology of that. You remember the basic structure of the Constitution should not be disturbed. This doctrine of basic structure was, decided by the Supreme Court in Keshwanand Bharti case. Okay. Just note down this. We will be discussing it many times. Bharti case in 1973. Okay. 42nd Amendment came in 1976. So, its constitutional validity on the text of basic structure was examined in Minerva Mills case in 1980. 73 propounded the doctrine, 76 amendment came, 1980 it was tested on the touchstone of basic structure doctrine and it was upheld. That is why these words are still there. What is the parliamentary sovereignty and judicial supremacy? Both these terms are very, very important. It is basically, we can say in a rather layman's language, who is supreme? Is it the legislature who is supreme or is it the judiciary who is supreme? Legislature makes the law, judiciary interprets the law. Both, I should say, this is my own observation as a law student, both have supremacy in their respective areas. How? See, you might have observed that sometimes issue comes before the Supreme Court where there is a need for a new law. Okay, a situation comes where it is felt that there is no law which fulfills, which addresses that situation. No law on the statute. So, in that case, it is not that the judiciary takes the responsibility of making the new law to fill up that gap or to address that situation. They simply say it is the job of the legislature. Please go to legislature and get a new law from there. Our job is only to interpret. And during that interpretation, through the case decisions, some aspects of laws emerge out of it and we call it, the judge-made law. Though truly it is not made by the judges, it is through interpretation, some facts or some aspects of that law which were not earlier known to us or which were not applied so far have now been applied through their interpretation. And that takes the form of a new law, but in reality, in actual terms, it is not a new law. It is just the interpretation of an existing law. And they are completely independent. In the case of judicial review or interpretation of laws, our judiciary is completely independent. They are not working under legislature or they are not working under the executive. For their decisions, they don't have to take directions from anyone. It is their own independent interpretation. And that is why we say that we have an independent judiciary. So, but who is supreme? Is it the judiciary who is supreme or the parliamentary? Parliament is sovereign in many aspects. How? Parliament can take any decision collectively, of course, which affects both the internal as well as external functioning or the matters of the government, of the state. How the nation is to be run, what laws should be there, what should be permitted and what should not be permitted by way of law is decided by the parliament. There they don't have to take any direction or instructions from anybody. If there is if a need is felt in the society that there is a need for a new law or a different law or a law which is not fit for the present circumstances, present times. So in that case, that law has to be changed or a new law has to be made. There the parliament is sovereign. There they have the supremacy. But when it comes to judicial supremacy, they are supreme in their own functioning. So both are supreme in their own functioning. This is how your answer should be. If a question is asked, who is supreme? Whether parliament is sovereign and supreme or the judiciary is supreme. No, they are both supreme in their own spheres, in their own way of working, because there is a complete separation of powers. There may be some, overlapping here and there, but as far as their basic job of, making the laws and interpreting the laws, both are supreme in their own spheres. Now, doctrine of sovereignty of parliament is associated with the British Parliament because they can make any law. And principle of judicial supremacy is with respect to American Supreme Court, where the court's decision is final. So they can strike down, they can create a new law through their own judicial, pronouncements. But not in India. Yes, here we have the independent judiciary. They are supreme in their own functioning. Now we have the integrated and independent judiciary. There is a single system of courts which enforces both the central laws as well as the state laws, unlike in USA. Now, what is the position in USA? They also have a federal court, that is the Supreme Court. But Supreme Court will not rule on the state laws. That is left to the state judiciary because they have a truly federal system. The units in the federation have got more autonomy as compared to what we have in our federal system. There the states have more rights, more autonomy. And the state judiciary also has got more autonomy as compared to our state judiciaries, like high courts or lower courts. There, the matters relating to state laws are finally decided by the state judiciary. They will not come to the Supreme Court. Supreme Court will deal with only the federal laws. So the scope of judicial review, the power of the Supreme Court in India is narrower than that of what exists in USA. How? Because in American Constitution, there is a due process of law. See, these two terms, due process of law and procedure established by law, we will be studying in detail when we study Article 21. What does Article 21 say? Article 21 says that nobody will be deprived of his life or personal liberty except according to procedure established by law. Procedure established by law has got a limited scope. There must be a law, there must be a procedure. And if that procedure is followed, then you can take away the life and or liberty. That was the original provision, original interpretation. Provision is same, but the interpretation prior to what case? Prior to Menka Gandhi case, that was the situation. That there must be a law, there must be a procedure. But now, and in the case of due process, the judiciary can examine any aspect of that law, that process of law. Whereas after Menka Gandhi case, there are only three factors which have to be examined. One is that procedure has to be fair, procedure has to be just, and the procedure has to be reasonable. Now, this has led to some kind of semblance with due process. And people say, the jurists also say, or the people in the legal profession say that the due process of law has entered the Indian legal system by a back door through these terms in the Menka Gandhi case. But this, if you see, when we will study in detail, you will feel that this is only a limited type of due process. Due process is a much, much wider term. It can, look into any aspect of the process. But in India, after Menka Gandhi case, it has to be tested only on these three touchstones. So here, the Supreme Court is a federal court. It is the highest court of appeal. The final appeal lies with the Supreme Court, guarantor of fundamental rights of the citizens. Article 32, judicial review is there. The guardian of the Constitution. Now here, there are two. One is that Article 32 for what? Judicial review. What do you mean by judicial review? Judicial is by the judicial process, by the judiciary. Review means if any action is there, any law is there, any executive order is there, any executive action is there, it is subjected to a review by the judiciary. Judiciary will decide whether it is adversely affecting the fundamental rights of the citizens or not. That is under Article 32. It is also one of the fundamental rights. Guardian of the Constitution is, after Keshwanand Bharti case, as I said, that any part of the Constitution can be amended, but subject to what? Basic structure doctrine. So that means if the Parliament decides to change the fundamental or the basic structure of the Constitution and passes such an amendment or a law, that can be struck down by the judiciary, the Supreme Court. Because if it is violative of basic structure, if it disturbs the basic structure of the Constitution, it can be declared as void, can be removed. It will not have any effect. So this is how it is the guardian of the Constitution. Now, the constitutional provisions are to ensure its independence. How? Whose independence? The independence of the judiciary. Security and fixed service conditions of the judges That means the judges cannot be removed so easily. There is a impeachment process which has to be followed. So there is a kind of a security and the fixed tenure, fixed service conditions which are provided to the judges. That leads to the, that is one aspect of the independence of the judiciary. Now, their expenses are met from the Consolidated Fund of India. We will study this when we study that part of the Constitution. It is basically the Consolidated Fund is where all the revenue comes and all the expenditure is incurred. So, from that Consolidated Fund, the expenses relating to judiciary are spent. That gives another form of security and independence, because for the funds, for meeting their expenses, they don't have to look for other sources. There is one single source, that is the state, through its consolidated fund. So there is prohibition on discussion on their conduct. Where? By the legislature. That means their conduct cannot be discussed in the parliament or in the legislature. This is a prohibition on the legislature by the constitution. Now, there is a separation of judiciary. That means judiciary is not to be controlled by either executive or by the legislature. Ban on practice after retirement. They cannot practice as an advocate in any court once they retire as Supreme Court, judge of the Supreme Court. They can be appointed by the government to some post, like, they have been posted as governor of a state. One Chief Justice, Justice Sadasivam, was posted as the governor of state of Kerala. Recently, the former Chief Justice of India, Justice Ranjan Gogoi, has been made the Rajya Sabha Member of Parliament. So, that is not a ban. There is no prohibition on that. But they cannot practice in any judicial forum. Okay? So, separation of judiciary from executive. Executive have no control over judiciary.